introduce our moderator, Professor Echeverria. He's a professor at Vermont Law. Prior to coming to Vermont, he was the executive director of the Georgetown Environmental Law and Policy Institute at Georgetown University. He earned his JD from the Yale School of Law, and most importantly, he has the distinct honor of serving as VGEL's faculty advisor. So, thank you for moderating for us, and Professor Echeverria.
Thank you, and congratulations to VGEL for his so far fabulous conference, and promises to be a fabulous conference. So our first panel focuses on the Chesapeake Bay, which is at least arguably equal in ecological and economic and social importance to Lake Champlain, so worthy of attention. Beyond that, we're focusing on the Chesapeake Bay because it is the subject of a very important piece of litigation which is ongoing. In July, the Third Circuit issued an important decision in American Farm Bureau Federation versus U.S. EPA, and the case is not yet over. So we're going to focus on that. We have four distinguished speakers, and I'm going to give very brief introductions. Apologies if you want to know more about them. I'm sure they'd be happy to tell you. John Mueller is the Vice President for Litigation at the Chesapeake Bay Foundation, previously served as an environmental lawyer in the U.S. Department of Justice. Our second speaker is Richard Schwartz, a very distinguished veteran of environmental litigation, who's a partner at the major D.C. law firm of Crowell and Mooring. Our third speaker is Mary Jane Angelo, a longtime friend of Vermont Law School, and who is a professor of law, alumni research scholar, and director of environmental and land use law program at the University of Florida, Levin College of Law. And finally, our Nina Bell, who's the executive director of Northwest Environmental Advocates in Portland, Oregon. And just to give you the plan, John will go first, provide you an overview of the Chesapeake Bay pollution problems, a thumbnail sketch of the past efforts to clean up the pollution problems, and then describe the TMDL program. Rich will then turn to the litigation that is the focus of this panel, talk about the trial court and the Court of Appeals decisions, and describe the current status of the case. We will then, the next two speakers will then use this case as in a sense, as a starting point for talking about issues in other parts of the country. Mary Jane will comment on the American Farm Bureau Federation case in the context of the similar but different and very serious water pollution problems in the Everglades. Nina will then take us to the Pacific Northwest and talk about TMDLs in that portion of the country. And so without further ado, John, you're up.
Good morning, everyone, and thank you very much for inviting me to come and speak today. I'm really excited about it, and after listening to the bummer conversation from Professor Owen, I'm hoping that we are going to make some real advances with this TMDL. But I think it's important to understand the background and the history and how we got there, which I think would be a good prelude to what Richard's going to talk about as to actually what happened in the litigation. So first I'm going to give you a little background, explain the voluntary efforts and all those things we've called other than TMDLs, and then the Bay TMDL, and then again just kind of a brief mention of the litigation. So just to get you oriented, we're talking about the largest estuary in the United States, 64,000 square miles, 6 jurisdictions, including the District of Columbia. 17 million people, growing all the time, so a lot of pressures from all of those inputs that Professor Perroteau spoke to you about this morning. So what are the resources we're talking about? Blue crabs, giant fishery in the Bay region, very important throughout the Bay region as an economic source for watermen, restaurants, seafood industry, Oysters, same thing here. When you read about the history of the bay, the oysters were so plentiful at one time that they were actually a hazard to navigation within the bay. Now they're down to 1 to 2% of their historic numbers. Fishery, this is a rockfish caught right out in front of our office actually. Striped bass, another anadromous fish, but great resource within the bay. Number of other species that are very important to the economy within the Bay region. And one species that's pretty much overlooked are the importance of underwater grasses, submerged aquatic vegetation. They are the nursery grounds for the blue crabs and for the small fish before they become mature, so they can escape predation. They are smothered by too much sediment, and they are smothered by too much algae, and I'll get to that in a minute. And of course, we talked about all these great resources, but we can't overlook their importance to the human environment and human aesthetic. We always talk about in standing cases about the aesthetic enjoyment to our members and to people. And I think one of the things that's most important for us as environmental lawyers is to remember to relate the resource to humans. So problems in the bay, not unique. Too much nitrogen, phosphorus, and sediment. This chart just shows the nitrogen and phosphorus inputs, and no surprise, agriculture is leading the way. We've done a lot to restrict the point source discharges into the bay, but not so much on the non-point side, and so there's a lot more to do there, and that's what this TMDL aims to address. So we have large animal feeding operations, direct discharges, Blue Plains in Washington, D.C., the largest wastewater treatment facility in the world, was discharging close to 8 milligrams per liter of nitrogen. They're going to spend close to $1.5 billion to upgrade their plant and cut it down to 4. Development ongoing all of the time. 17 million people and more moving into the watershed. We get construction runoff, urban development. We get urban stormwater runoff. This is why the MS4 program folks spoke about earlier is so important. If we're not going to address urban runoff, we've got a real problem on our hands. You saw the earlier pictures of sediment plumes, but you can see the Susquehanna River, which is 55% of the discharge of fresh water into the bay, a major problem, but all the other major rivers, the Potomac, the Rappahannock, the Tucson, all large sediment discharges into the bay. Can't be solved by just going at one state when all 6 states contribute to the problem. And then we have air pollution, unseen. You don't see nitrogen oxide in the air, very difficult to try to address. We have power plants, automobiles, cement kilns, incinerators, all discharging NOx. One of the biggest sources is up the mobile source sector. Not really a whole lot being done there other than maybe through Tier 3 gas standards and some other regulatory regimes under the Clean Air Act, but still a large problem, especially now that we have this great proliferation of new poultry houses being built on the eastern shore and in the valley of Virginia and central Pennsylvania. They're a source of ammonia, and ammonia carries nitrogen as well. So what's the result of all this pollution? Algae blooms. This is just off the coast of Virginia Beach at the mouth of the Chesapeake this summer, taken by Virginia Institute of Marine Science researcher. The dark area there is algae. And when that algae blooms and dies, it consumes oxygen, falls to the bottom, takes up oxygen, and then we get dead zones. This is a typical summer on the bay. You can see pretty much from the headwaters of the bay up at the Susquehanna all the way down to the mouth. It's pretty much hypoxic or anoxic. The organisms, benthic organisms, cannot live because there's not sufficient oxygen for them. For creatures like oysters that can't move, it pretty much wipes them out. For others, like fish, these fish are actually in a creek right down the Severn River from my home, in which they go up into the small creeks at late evening and stay there during the day, or excuse me, during the evening. You have a lack of oxygen, they can't escape, and they all die. I saw a great picture from Professor Parento about Long Island Sound. It's a very similar phenomenon. I've actually been in the main stem of the bay out on the boat, and you just see, hundreds of rockfish floating on the surface of the water because during the summertime, anoxic conditions, they can't escape and they die. But we also can't overlook the impact to humans. And this is a flesh-eating bacteria. This gentleman actually just had a small cut on his leg when swimming and ended up with this very invasive bacterial species. People have been known to die from it. So the conditions present in the bay now with warming water temperatures is very conducive to increased bacteria growth, and we get these kinds of reactions every summer. So the Bay States and the District of Columbia and EPA got together and started back in the 70s to do some research about how the Bay problems could be resolved. These are the governors of Virginia, Maryland, and Pennsylvania getting together and signing one of the first Bay agreements. So in 1983, the states decided that we're going to do something about this Chesapeake Bay problem. We understand basically what the problems are. Again, too much nitrogen, phosphorus, and sediment. How are we going to control them? In 1987, they said we're going to reduce inputs to the bay from 1985 levels by 40%. And we're going to get there within 10 years. In 92, they re-upped and said, yep, that's exactly what we're going to do. We're going to get to that goal, and we're going to make it by 2000. They wrote another agreement in 2000 and said, oops, we didn't make it. Now we're going to shoot for 2010, and we're going to try and get this resolved by 2010. Congress got in the act. He's smiling here, but I don't think Nixon was really that happy about this, but he had to actually sign in and make effective Section 117G of the Clean Water Act, which says that EPA shall coordinate with the states to meet the goals of the Bay Agreements, those agreements that were listed on that prior chart. But then we also had Section 303D, the TMDL section, to rely on. And so, as others have spoken, what are we talking about here? We've got waste load allocations, which are for point sources, load allocations for non-point sources, natural background, and margin of safety. How do you do that for a 6-state region with multiple source sectors, as I showed from the prior slide? A big effort. We had the constructive submission litigation that others spoke of this morning, which basically forced the state's hands to actually develop the TMDL. The American Canoe decision in Virginia was particularly helpful because it definitely forced EPA's hand and Virginia's hand to identify the problems in the Bay, how they were going to resolve the problems for the Virginia sector of the Bay. And so it definitely pushed things forward. As part of the voluntary agreements, there was a council of states that was put together to help move things forward under these Bay agreements to try to beat the 2010 deadline, because they didn't want to get stuck with having to do a TMDL. And so they called it a lot of things other than a TMDL. They called them tributary strategies. And so their idea was that we're going to reach this goal, but by the time they got to 2007, they realized there's no way we're going to make it under this voluntary process. And that's the problem with the way, when you start calling it something other than a TMDL, you don't really have much of a regulatory driver. And I know we're going to talk a little bit more about how effective that driver is, but when states can keep coming back to you and saying, well, sorry, we missed this deadline, and sorry, we can't make that deadline, you don't really have much place to go other than through the TMDL process. So the states came to EPA and said, we need you to start developing a TMDL as far back as 2007. We got a little frustrated with the whole process, and so we sued EPA in 2009, saying you've got to develop a TMDL. We raised a couple of, I'm sure folks here would say, novel legal theories about how we're going to do that. We argued, in fact, that other than failing to meet the requirements under Section 117G, that those Bay Agreements were interstate compacts that had been ratified by Congress and had the force of federal law. It was a little unnerving for me to have to sit across the negotiating table from my old boss, John Cruden, and have him tell me I had no case, but we had some great allies here. This is former Maryland Senator Bernie Fowler, a longtime Bay advocate. He does a wade-in on the Patuxent River every year because he remembers as a child and as a waterman how clear the water was. He does a wade-in with his white tennis shoes to try and see how deep he can see down to the bottom. Taylor Murphy, Secretary of Natural Resources for Virginia, Tony Williams, Mayor of DC, and former Maryland Governor Hughes, and a couple of sport fishing and watermen's associations joined with us in this lawsuit. And these gentlemen were all signatories to those Bay Agreements, and to each one of them told me, you know, I thought we were going to make some progress. We thought we were going to make it voluntarily. But we haven't, and they basically, the federal government and the states have not done their job, and so we need to do more, and so they supported our lawsuit. So we settled with EPA. They agreed to establish a TMDL by the end of 2010. They said they were going to develop these implementation plans that each state would have to write on how they were going to meet the TMDL allocations, that they would require reasonable assurance. And I know we're going to talk a little bit more about that very important aspect, and that EPA is going to exact consequences, and I know this makes Richard's hair stand up on the back of his neck when we talk about this, but EPA does have some tools. It can withdraw federal grant funding. It can deny point source permits if states aren't making progress. President Obama issued an executive order telling the federal agencies that they had to get in line, that they had to figure out, as major contributors to the Bay problem, how they were going to resolve their discharges. And then the TMDL was issued in December of 2010. The process was EPA proposed allocations. The states then wrote implementation plans, draft implementation plans, which EPA reviewed and said, you know what you've got here for a couple of the states, like Pennsylvania and New York, not going to get us there. Using reasonable assurance, said you got to go back to the drawing board. You got to do a better job, or we're going to institute backstop allocations, which means they're going to lower their discharge level even further. The states reissued their whips. They were approved by EPA. And the TMDL, one of the interesting things about it, and probably one of the more difficult things about it, is that it relates to 92 different segments within the Bay watershed. So all those different rivers and streams that discharge into the Bay and contribute to the overall problem all have separate allocations. The deadline is 60% of the practices will be installed by the states by 2017, and then they will have 100% of the practices by 2025. Long time out, we bristled at that, certainly, but given the level of effort that's necessary to make this happen, we think it's a reasonable goal and should be attained. But the Farm Bureau didn't agree, and I'll turn this over here to Richard at this point, because I'll let him talk about the litigation. Thanks very much.
Comment that John is going to get a free lunch because he came in on time. That is setting a fabulous model for other speakers.
And a great challenge for the rest of us. So I'm going to talk about the litigation now. If I go, but like this, nothing happens. Whoops.
That's one to the end. There you go.
Let's see. That's not on. Oops. No. While they're doing that, I have just a couple of comments, just to sort of try to clarify things with respect to efforts that were made prior to the issuance of the TMDL. And that is that there actually was progress prior to the TMDL. This has been a long effort. You have to recognize that with 64,000 square miles, and that's not it either. I'm gonna have to wait till they get this. I'm like everybody in the audience. Every time I see a screen, I can't take my eyes off. No, my computer. It's on my desktop on my computer. And I could do it without the slides. If this doesn't work out, you just have to imagine a screen.
I encourage you to watch, and we will catch up.
Yeah, I'll bring it up on a home drive.
Okay. The case that we're talking about is American Farm Bureau Federation versus EPA. It was decided by the Third Circuit on July 6th of this year. There's going to be a cert petition filed. The cert petition is due on November 7th, and then we'll have to see what happens after that. This case is interestingly one largely of administrative law, and I'm going to and the statutory limitations on TMDLs come up in an administrative law context in terms of how much deference does the EPA get in terms of making an expansive interpretation of language that is at best not clear, and we would say does not support the way EPA is interpreted. Now, to be clear, two things. John and I both have talked beforehand. The case is still ongoing. I represented one side, John represented the other side, so while I'm going to describe the opinion, I'm also going to talk about some of the weaknesses I think I see in it. In terms of background, the other thing I wanted to clarify is that there, in fact, since 1983, there have been voluntary efforts that John described. They have resulted in reductions both from agriculture and from publicly owned treatment works. And in fact, the projected reductions before the TMDL was adopted are very, very similar to the ones that are included in the TMDL. And that reflects the fact that, as Professor Owens discussed earlier, it's been recognized that TMDLs are informational and do not impose implementation requirements. And so that's one of the limitations. It's structural. It's part of the Clean Water Act that's involved with this. Now, the first issues the court dealt with were issues that are involved in many environmental cases, and that includes standing and rightness. And what the court... Okay, all right. So we could go to the statutory framework just briefly. And the lesson from this slide is that there's a series of steps that have to be taken to meet water quality, and the TMDL is one step in many. And the question is, what's included in this step versus what should be in the other steps? The first thing that happens is states set water quality standards, and if they don't do it properly, EPA has backstop authority to set its own. Once water quality standards are adopted, states are required to list impaired waters, which are waters that don't meet the water quality standards that they just set. And if they don't do that, EPA again has backup authority. And then the question comes, well, the next step is if the water is on the impaired waters list, what has to be done about it? And the first thing is that the states are to establish TMDLs, total maximum daily loads, which defines how much pollution a stream can take and still meet its water quality standard. And I have to admit, I read this a long time ago, and I thought the step was basically you're setting a cap on pollution, and so the purpose is to set a loading as opposed to concentration-based limits. You're saying how much pollution can this take from anywhere, and then once you do that, then you do implementation. You decide how am I going to meet that load, and that was sort of my common sense understanding of what this meant. EPA, and that was to be followed by a couple of things that were put within the domain of the states. One was a state continuing planning process under the next provision of the Act. There's a provision in the Clean Water Act for area-wide waste treatment, which involves multi-jurisdiction pollution problems. The governors are supposed to identify them and take care of them, and that applies to both point and non-point source pollution. And then the probably most important one for our purposes is Section 319 of the Act, which this court didn't discuss at all. It didn't discuss 208, it didn't discuss 319. Section 319 has a detailed program for regulating non-point sources of pollutants. And our view was that much of what EPA put into the TMDL should have been put into the Section 319 plan or a 208 area plan. And that's the issue. Do these steps belong under the TMDL, or do they belong in under other sections of the Clean Water Act? Now, to go to standing, look at that. In many environmental cases, standing is an issue, and often rightness is an issue. And the courts generally have been tougher on standing in environmental cases in many instances. Here, the court had to deal with the fact that it's universally recognized that TMDLs are supposed to be informational tools. They're a step in the process to achieve water quality standards. And so if they're just informational tools, how does anybody have standing to challenge them? How do they cause injury? And what the court said was that there would be likely economic injury eventually, once they were implemented, and that would be enough to create standing even before regulatory action fully takes place. Now, from the environmentalist group side, standing is also an issue, but it's a different discussion. The Supreme Court's decision in lay law is the one that's always referred to. And that involves injury due to use of a stream in the case of the Water Act, and that kind of injury is often presumed to be redressed by, first of all, caused by inadequate regulation, and would be redressed by stronger regulation. And so that's where standing comes from for environmental groups. For industry, it's an economic injury. And what the Third Circuit said is that the likelihood of economic injury would be enough to give them standing. For rightness, the issue is fitness for judicial resolution and hardship. The court found that this was a clearly legal dispute on a well-developed record, so it was fit for review, and that the regulation would cause hardship both to plaintiffs, both to industry, and to defendants, to the states that have to implement this rule if it was later overturned. Now, if you get to the meat of the case, you're talking about the Chevron doctrine, which is the amount of deference that is given to an agency to interpret a statute. And there are two steps to Chevron. Step one is whether the text of the statute shows that Congress resolved the problem, in which case you stop there. If you get to step two, the court has found that the Congress has not directly dealt with the problem, and so in that instance, the agency gets deference in terms of its interpretation, and its interpretation will be deferred to if it's deemed to be reasonable by the court. So it's a very friendly standard of review for administrative agencies. Here the issue goes to two parts of the Chevron doctrine. One is whether Congress left gaps in the statute that needed to be filled by the agency. And what gap filling involves is an assumption that Congress intended to give gap filling powers to the agency. And therefore, if that were the case, then you'd go to Chevron step 2. The court noticed two things about the TMDL process. One is there have been a lot of TMDL cases, but the issues raised by the Farm Bureau were raised for the first time. So they're essentially saying, if this was so bad, why didn't someone raise it before? The second was that you're dealing with a complex regulatory scheme, and that due to that, in that situation, it's a technical statute. Congress tends to defer to the agency. Now we get to the statutory text that raises the judicial question, and the text is simply describes a total maximum daily load at a level necessary to implement a water quality standard. And the position taken by the Farm Bureau is that this is actually pretty clear in one sense. It's just a total. It's a total number. And as I said, the Farm Bureau felt that this was simply one step in the process, not the final step. But the question is how much is involved in this step. And the reason that has consequences that are significant is that with respect to this step, EPA has backstop authority. So EPA becomes the ultimate decision maker about what's included in the TMDL. With respect to the subsequent authorities relating to implementation, ultimate authority goes to the states. And so if you're the Farm Bureau, essentially you're saying that the state governments have been given this authority, and that's where it belongs. It doesn't belong with EPA. Not that it will never happen, but that the tough decisions need to be made by the local governments. Now, what the court said was it found ambiguity because the word total, it says total maximum daily load, and total would be redundant with maximum if we didn't construe this broadly. It's an argument I still don't understand, frankly. Maximum daily load is something, and a total maximum daily load seems to me to be the total, and you'd have to read the court's decision, but I frankly just didn't find it persuasive. A second argument was that you need all these other elements, the elements being allocations, reasonable assurance, and deadlines, because otherwise how would you know how you got there, how you got to the cap, which I think is absolutely true, but there's a separate question as to whether all that information needs to be part of the regulation itself, as opposed to the information you provide in a preamble, which is where information usually is provided. And finally, that the broader interpretation was consistent with the statutory purpose, and it achieved the results that EPA was looking for. So then if we get to allocations, the court, when it looked at the specific elements that were included in the TMDL, the court said that control of point sources is not enough, so you must consider non-point. And what the court actually failed to recognize is that the trigger is when technology-based standards don't meet, aren't enough to bring water quality up to state standards. But technology-based standards are not the endpoint for regulation of point sources. So, in fact, you have water quality-based standards, which are mentioned earlier, and depending on what stream an industry or a publicly owned treatment works discharges into, the effluent-based standards, the water quality-based standards are actually controlling. And increasingly, as water quality-based standards are lowered, that's the direction they go, more and more direct discharge permits are actually based on exactly meeting water quality-based standards. And that was just simply something the court was not familiar with. The court also said, well, this is just common sense. And then the court said that EPA isn't commanded to include allocations in a TMDL. There's nothing in the statute that requires it, but we find it's allowable, that it's a permissible interpretation of the statute. which the court then approved under Chevron Step 2. With respect to deadlines, the court simply said, well, if you're going to require this to be done, you got to have a deadline. So that's just common sense, and that's the term the court used in the statute. And I think it's something that rarely is attributed today to the United States Congress, but the court nonetheless did. With respect to reasonable assurance, it was a similar kind of analysis. Well, if they're going to allocate certain amount of pollution to non-point sources, they got to have an idea that this, whatever their allocation is, actually will be met. And so that justifies reasonable assurance. The EPA had to satisfy itself that the position that the allocation was proper. And so the phrase that the court used was that the TMDL, quote, has enough play in the joints, close quote, to allow what EPA did. There are a couple of other points that were not crucial to the litigation, but one is the question about federalism. And the court distinguished the Swank and Rapanos cases, which relate to the scope of waters of the U.S. defined under the Clean Water Act, and said that because we're not dealing here with an actual definition of the scope of the agency's authority, we don't find this sort of small intrusion and violates the federalism, the split in the Clean Water Act between the states and EPA and the powers that are given to each. And finally, with respect to constitutional avoidance, which I think actually he hadn't raised at all, the court said that the Chesapeake Bay is clearly part of it's a channel of interstate commerce. And so for that reason, there's no question about constitutional avoidance here. And we get to Chevron Step 2. The court found, simply repeated, that total can mean a sum of parts. And I would say, yeah, but the operative noun is sum. And the allocations are not the sum, and that's what the statute refers to. It found the legislative history was unhelpful, which I think is true. And finally, it said that they needed EPA intervention to clean up the bay. That is something we discussed, and I think it relates partly to what Professor Owen said about how much of this is actually done by the states versus actually done by EPA. Ultimately, with TMDLs being an informational tool, you require state authority to do the cleanup, and EPA's guidance and help and certain carrots and sticks that EPA has are undisputed. The question that was decided in this case is how much of that goes within the umbrella of the TMDL, how much goes outside. And the court said that this was appropriate for going within the TMDL. The only other, my time is up, so the only other thing I'll add is that in the briefs, aside from the literal language, the primary point we made is that we felt there was no gap here because sections 208 and 319 provide detailed requirements, I mean extremely detailed if you want to look at them, about how you regulate non-point sources and how you deal with area-wide treatment problems. And so there was no gap, and the court ignored that point. And so that's one that may have to be saved for another day. But it goes to the point that Professor Owens made about, how you get it done and where you get it done, how much can be done by the states, how much the states have to do anyway. And that will be resolved in the future. Thanks.
One question that arises in my mind is whether the issues that are being raised are issues that might be raised with respect to any TMDL, but that this TMDL is different because it arises out of a settlement, and the states agreed in advance that they would put in place implementation plans, and they would agree to assurances. And so I'm wondering if there's something, if you could each very briefly comment on whether there's something distinctive about the process that led to the Chesapeake Bay TMDL program that might make some of these arguments not pertinent and might make the case not certain.
All right, well, I guess you're looking at me. The point, that's actually an interesting point, because so much of environmental law has been generated by consent decrees or by between EPA and private plaintiffs. I think the answer is that the issues raised are issues of statutory interpretation. In other words, what is the scope of EPA's authority under this phrase in Section 303 of the Clean Water Act? And the rule is that by agreement with anyone, EPA can't expand its authority over what Congress has delegated to EPA. And so our view is that the consent agreement has, between the some states, I believe, and John's organization, it affects their ability to
Time's
challenge
up,
it.
Counselor, because I'm intruding the other speakers.
Okay, I'm sorry.
I wanted to say a few.
Yeah, please.
Well, just, that argument overlooks Section 117G, which says EPA shall, and EPA did, and that's where we are today. So I don't know that it makes it unique, it just follows on the statutory language.
Okay, further to be discussed further.
Okay, so it's interesting to be here talking about TMDLs in 2015 when I got out of law school and went to the Environmental Protection Agency in DC. My very first case was a Clean Water Act case, which probably a lot of you law students know is the Arkansas versus Oklahoma, dealing with whether one state has to comply with another state's water quality standards. And so when I got the case assigned to me, the first thing I did was say, where are the TMDLs? I thought there was going to be a book of TMDLs because I learned about it in law school. And of course, at that time, there weren't any. So now, although it's many years later, we have moved on. We have a lot of TMDLs. We have implementation at least starting in some places. So, well, this is a Chesapeake Bay panel, and somehow I'm talking about the Everglades, but all right. So, and I'm going to talk a little generally about TMDLs in agriculture as well. We've talked about a lot of this before. Two of the primary problems with agriculture are nutrients, phosphorus and nitrogen, and sediment from agricultural runoff. We know about the dead zone in the Gulf. I put this particular slide up about the algal bloom in Lake Apopka in 1995. This is the second biggest lake in Florida, and you can see it just was like a pea soup at that time, and that little line is the wake of a boat sort of pushing aside the algal growth. I wasn't going to talk about this, but it is a success story, a TMDL success story. I was working for the agency in charge of regulating water issues in Florida at the time. We tried to address this through voluntary means, and we also tried to address it through litigation, and we got nowhere until we set what we called a pollutant load reduction goal, but it's really the same thing as a TMDL. And then we had a very specific target, so we could come up with the budget, the phosphorus budget for the lake, and figure out what we had to do to meet that target. So that TMDL target was met. And I didn't bring the picture, but picture it in your mind, a very clear lake with submerged aquatic vegetation and fish, which it hadn't had for decades because of the excess phosphorus in the lake. And it was a very multifaceted approach to meet that. So it was an example of setting a TMDL, meeting a TMDL, and coming into at least very close compliance with the water quality standard that hadn't been met in decades. Okay. Why is agriculture such a problem? We've talked about this a little bit. It's exempt or excluded from NPDES permitting because most of it's not considered a point source. Many states exempt or exclude agricultural runoff from their regulatory programs. There's something that hasn't been discussed much yet, but I want to mention is narrative criteria. A lot of states instead of having a numerical water quality criterion for nutrients, they have narrative criterion, and I'll show you example one in a minute, which makes it a lot harder to both set TMDLs and to enforce water quality standards. We've talked about the diffuse nature of pollution, and then the other thing I want to talk about is reliance on BMPs or best management practices. So, NPDES permitting for point sources, we've talked about technology-based, water quality-based standards, but when we're talking about these permits for point sources, we put these numbers, these effluent limitations in the permit, whether it's a T-bell, the technology-based, or a Q-bell, the water quality-based. But there's a number that we can put into a permit. It's not as straightforward with non-point sources. And I really think the issue is implementation once you've set the TMDL. So this is the way I like to think of a TMDL. It tells you how much of a particular pollutant a water body can assimilate without violating a water quality standard. So it's basically a tool to try to translate that water quality standard into something that you can put in a permit or have as a restoration goal. Oh, this is just a process, I'll go past that. Okay, so this is what I mean when I talk about narrative standards for nutrients, which many states have things like this. Okay, in no case shall nutrient concentrations of a body of water be altered so as to cause an imbalance in natural populations of aquatic flora and fauna. What does that mean? How do you set a TMDL for that? How do you enforce that? How do you implement a TMDL for that? And that's been a real roadblock, I think, in dealing with nutrient pollution. Some of the pros of narrative criteria are it allows for sort of site-specific interpretation instead of one-size-fits-all. But, it's very difficult to enforce, to set a TMDL for those. Whereas numeric can set a bright line, make it very clear what has to be met, and makes establishing a TMDL much easier. So these are my pictures. I'm going to run through them quickly. Okay, do I have a pointer? I don't think I have a pointer. Oh, I do have a pointer. Okay, so we have our stream. The state sets a water quality standard. It's designated use. We're just making up numbers here. Let's say the criteria is 55 parts per billion for phosphorus, but the actual concentration in the river is 200. So somehow it's impaired. We have to get 200 down to 55. How do we do that? First step, set a TMDL. Not as easy as it looks, and that's why it can cost $1 million+ to set one. It's looking at all these processes that go on in the water body. It's assimilative capacity based on things settling out into sediment, nutrient cycling, sun, plant taking up the nutrients, and all these things that go into it. So let's say we do all this sophisticated modeling and we come up with a TMDL of 15 tons per year. That's how much can go into the river. If we're in a point source situation, it's fairly easy then to allocate that. Let's say each of these do 10 and discharge 10, and we have a total of 20. We need to get down to 15. Okay, we can decide how to split that up based on various things. Between the two, we can take those numbers, use them as a Q-bell in the NPDES permit. We're good to go. In the non-point source situation, assuming everything's the same with the water body impairment and the TMDL, question number one, how do we know what the actual discharge is? It's diffuse runoff pollution. How do you monitor it? Where do you monitor it? It's much harder to measure that. Point number two, even if you know what it is, how do you implement it? So I'm going to talk about this in a second. What a lot of places do are these BMPs, best management practices, which are non-numeric design standards. Okay, we use these, and we don't know if we've actually met the discharge limitations or not, because it's all non-numeric. And so how do we get the farms to meet an allocation in the absence of a NPDES permit or state permit that contains numeric standards? These are, let's get that. So we've talked about how EPA regulation does not directly regulate these agricultural non-point sources. So we have three broad categories of sources, or we have two left: the voluntary programs and the market-based and incentive programs. This is an example of one of the BMP programs, and this is Florida, but some other states have similar things. In Florida statute, if an agricultural facility is complying with certain approved BMPs, there's a safe harbor, so they're presumed to be in compliance with both the TMDL and the water quality standard, regardless of what's actually coming off of that farm. The mere compliance with the BMP creates this presumption. Other states, a lot of other states use BMPs, but they do it through incentive programs, either state incentive programs to help farmers comply, through the federal Farm Bill EQIP program. Florida and some other states also have ecosystem services payment programs. Shortcomings of BMPs, they're not very effective in some cases. There's a wide range of efficacy. I asked a BMP expert, can you give me a range of the efficacy of BMPs? And he said, yes, from 0 to 100. So, you know, it's like, they're very hard to enforce, because again, we're talking farm by farm, and we're talking about diffuse runoff, and difficult to verify at the compliance. Water quality trading programs is another one. Let me just say a few words about trading, because I'm taking too much time apparently. Again, when we have the trading acid rain program under the Clean Air Act with trading, we have point sources. We can measure what's coming out. We can impose, we can say, okay, you're already emitting 10, you got to get down to, or you've found a way to get down to 5, you can sell that other 5 to somebody else. When we're talking about diffuse sources, it's really hard to set, to know what exactly are you trading. The other thing is, if you don't have TMDLs or numeric nutrient criteria in place, then how do you know how many credits you get? And I think the main thing, though, is agriculture is so far from meeting TMDLs in most places that there doesn't really seem to be anything much more they can do to really be able to trade much. Although there are some programs where trading is occurring. But I would say that a lot of that is there's a lot of uncertainty about whether the trade is really doing anything worthwhile. Okay, let me quickly talk about the Everglades. Big system, Lake Okeechobee, the largest lake in this nation that's within one state, half the size of Rhode Island. And this is all the greater Everglades area. Major problems from the way it's been engineered from its historic flow into its current flow, sending water out to the estuaries. We're trying to get that water back into the Everglades. That's the goal of Everglades restoration. It desperately needs that water for many reasons, and these are just some of the programs or projects in place to try to do that. But what's been holding it up for all these years is the water quality that the water quality is not complying with the standards, so we can't put it back into the Everglades. So this is Lake Okeechobee. This is what we call the Everglades agricultural area. You've probably heard of Big Sugar. We've got Big Sugar in there, but lots of vegetable farms as well. The water coming off of this area is so polluted that we can't put it into the Everglades. And the TMDL for Lake Okeechobee is 140 tons per year. The actual is about 500. And when it comes down through the agricultural area, there's more pollution being added all the time. Okay. What's interesting is that through a series of lawsuits and consent decrees, the courts have imposed very specific requirements, specific engineering requirements, deadlines on how to meet water quality standards, which has resulted in the construction of these stormwater treatment areas. The state has done that. Let me go over here, which is helping to bring down the pollution. There's also been the imposition of required, not voluntary BMPs for the farms in the area. But even with all that, we did a pretty good job. We reduced phosphorus loadings by 53% with BMPs, additional 79% through the stormwater treatment areas, but it's not enough. So, Judge Gold found that EPA's approval of Florida's water quality standards was in error and required EPA to do this amended determination, which was this complex engineering plan over the course of 20 plus years with very specific deadlines and site-specific requirements for additional stormwater treatment areas. That's the approval of a water quality standard, is that plan. And it required the addition of a lot more of these things to try to clean up the water more. So far, the state of Florida has spent approximately $2.5 billion, that's with a B, dollars on these stormwater treatment areas, but it's still not enough to restore water flow to the Everglades. Why? Well, we continue to import 11,000 tons per year of phosphorus into the basin through fertilizer. It's got to go somewhere. The soils are so polluted from legacy phosphorus from past agricultural activities that it's estimated it could take more than 2 centuries for that to just work its way out of the system. So there's a lot of phosphorus to be removed. However, we have almost reached water quality standards for the water that's currently being treated by the STAs. We're like this close. That's not for bringing all that water that's going to the estuaries right now back into the Everglades. That would require more, but we're really close. So the lesson I take from this is the way that we got this far, although it's very expensive, was to use what I call a treatment train, where we have BMPs, and then we take that water that's partially cleaned up and put it through some kind of regional treatment system like the STAs. And it's all based on having numeric performance standards, not just some narrative criteria. The link to the case, let me say one more thing, is the case that was just discussed is and I think the case was largely about statutory interpretation, but if EPA were to follow a similar approach in other TMDL approvals or establishment of other TMDLs, you could end up with these kinds of plans that have been applied in the Everglades with specific deadlines and implementation plans for other basins, which could help move the process along.
Nina mercifully does not have a PowerPoint.
I'm old-fashioned, primitive from the West Coast, the Northwest. So before I actually start talking about TMDLs, I wanted to say that I used this opportunity to take a vacation in Maine, which still has its leaves on its trees. And driving from Maine into Vermont, I was startled by the fact that all I saw were trees. I never saw clear cuts. And I'm not saying they're not out there, but since I don't have slides, just imagine the difference between the Northeast, where you just see all these trees, and if they're clear cuts, you're not seeing a whole lot of them, and the West Coast, where you drive someplace and you just see these massive clear cuts, the entire tops of mountains just shaved of all of their trees and devoid of most vegetation and all the wildlife that goes with it.
We're better. We're better.
You're different. You're different, because we have a lot of lovely threatened and endangered salmonids that you might like to eat. But anyway, but to TMDLs. The promise of TMDLs is that they sort out the respective responsibilities of point sources, non-point sources, and Mother Nature. In an ideal world, a TMDL is done, discharge permits are written based on its waste load allocations, and non-point source controls are improved based on its load allocations, which are turned into clear, and I would say numeric, best management practices, or BMPs, the one acronym I'm going to share. The reality is starkly different. TMDLs are completed at a glacial pace, notwithstanding the number that have been done. They establish waste load allocations based on wildly unrealistic predictions of non-point source control and reductions, and non-point sources go on their merry way, polluting with impunity. As someone who has been involved with TMDLs and TMDL litigation since the early 1990s, despite the realism of all of that, I cleave to the first and optimistic view. I guess I'll be working for a long time. The Pacific Northwest has a peculiar love-hate relationship with TMDLs. Oregon is still rather proud of its status of having been the first state to have been the subject of the EPA lawsuits that rippled across the country starting in 1986. It staunchly defends the TMDLs that we are challenging in federal court right now. But the state has an odd notion that the TMDLs can be ignored for purposes of setting permit limits, for purposes of setting BMPs to control non-point sources, and in that middle place where point sources seek to offset their discharges by trading for pollution controls from non-point sources. In other words, TMDLs are loved so long as they are deemed irrelevant. The water quality context in Oregon is this. As I just mentioned, we have a lot of cold water salmonid species listed under the Endangered Species Act. We like to cut down trees. And it's being the West, we're not too keen on keeping waters in the river unless they're behind dams. As a consequence, the most widespread pollution problem in Oregon is temperature. So I'm not going to talk about nutrients at all. The nature of temperature pollution has posed problems for the establishment of the water quality standards, which are the foundation of the Clean Water Act Section 303 water quality-based approach, which includes but is not limited to TMDLs. While Oregon adopted numeric criteria to protect the salmonids, the state sought to exploit the fact that some major rivers historically exceeded those numeric temperatures. The temperature standards were then drafted to include language that I would say is a very insidious natural conditions provision. You'll find most states have a natural conditions provision. This one was special for temperature. And it allowed Oregon to use TMDLs to supersede those protective numeric criteria using the outputs of models that were developed during the TMDL process to supersede those numbers. So Oregon embraced this approach as the exception that swallows the rule, using TMDLs to virtually obliterate all the numeric criteria, generally across entire basins, because in Oregon, it's the West, we do things big, so our TMDLs are big. This is ironic, of course, because TMDLs are supposed to bring protection to salmon. We challenged this natural conditions provision, and the court vacated it. But that still left all the TMDLs that had used it in place. And I've been waiting since law school to be able to say the fruits of the poisonous tree. Truly. So we then challenged these temperature TMDLs that cynically changed the temperature standards from, and depends on what life cycle stage you're looking at, but basically 18 degrees Celsius to 32.5 degrees Celsius, which is the equivalent of 90 degrees Fahrenheit. Now, that was done without any federal agency review under either the Clean Water Act or the Endangered Species Act. While these TMDL superseding temperatures are not quite poaching or even sous vide temperatures, you get the idea that they are quite lethal. If you didn't, I just told you. Now, despite Oregon's facing a huge problem in restoring streamside vegetation necessary to cast the shade, to bring the waters into compliance with either standards and or TMDLs, it stands out in the West as the state with exceedingly bad state forest practices that lag behind its neighbors in establishing minimum riparian buffers on the sides of streams. For example, it provides zero protection from clear cutting to streams that do not have any salmonids, which is fully 70% of the stream network and is home to rapidly disappearing populations of things like frogs and salamanders. The development of temperature TMDLs, of which there have been many due to litigation, has had no effect whatsoever on these logging practices. So, to address the seemingly intractable problem of non-point sources, in particular logging practices, we sued EPA and the National Oceanic and Atmospheric Administration, known as NOAA, under an obscure statute known as the Coastal Zone Act Reauthorization Amendments, forever known as CZARA. CZARA does not require non-point source control, so it's no different than any of the other statutes that are out there in terms of being passed by Congress, but it is intended to induce good behavior in coastal states by cutting off grant funding to states that fail to obtain approval from both of those agencies for their coastal non-point pollution control programs. Note, programs, not plans. The statute has strict deadlines and funding cuts that go with those deadlines, and the dates are now long past. One requirement of CZARA is that states control non-point sources sufficiently to meet water quality standards. This, I think, rather obviously calls for the use of TMDLs, the kind that American Farm Bureau Court upheld, that divide the responsibilities of pollution sources into allocations and evaluate the sufficiency of non-point source controls, which underlies that reasonable assurance concept you've heard about. For Oregon and other recalcitrant states, which may have been all of them in the beginning, the federal agencies devised an illegal workaround around these strict statutory requirements that was premised on promises for Oregon of significant improvements in Oregon's poor logging practices, none of which, of course, have materialized. By suing, we sought precisely what Congress sought: effective non-point source controls. We settled the case based on Oregon's agreement to use a new kind of TMDL, well within their purview, because they're a state and they can, make up any kind of TMDL they wanted, that would demonstrate that the Oregon Water Quality Agency, which ours is called the DEQ, could and would address forest practices in lieu of the agency that regulates forest practices, which we had no faith in. They decided to call these quote-unquote implementation-ready TMDLs, which seemingly explains why the agency's plain vanilla TMDLs have never been implemented. That is a TMDL joke. In any case, they are best described as TMDLs that, and this was my idea, not theirs, but anyway, that would set the load allocations and then translate those load allocations into BMPs in the TMDL, not an associated plan. Oregon DEQ also agreed to issue enforceable orders to significant non-point sources, so not every little plot of land, but the significant ones, to follow the BMPs that were going to be developed in the TMDL. Note that identifying BMPs and a time frame for implementing them is precisely what Clean Water Act Section 319 requires of states outside the TMDL context. Now, while the CZARA settlement was not a silver bullet to obtaining non-point source controls, we felt it was good ammunition to move forward. Sadly, but not predictably, the tarnish on the not silver bullet set in immediately. Oregon DEQ quickly announced that instead of issuing enforceable orders to significant sources, it would issue them to something called, I never heard this phrase before, primary persons, and which turned out to be the very agencies that have been failing to regulate non-point sources all along. Ultimately, it repudiated the agreements altogether. Given that it was a tall order to expect the Water Quality Agency to set clear expectations for non-point sources based on a TMDL, we did have a backup plan. The stipulated agency called for the federal agency, the stipulated dismissal called for the federal agencies to make a proposed and final decision and cut the funds if the final decision was a disapproval. And it was promising. It was, after all, an order signed by a federal judge. Eventually, this January, the agencies did disapprove Oregon's coastal non-point program, and that was the first time in the nation that they'd ever done that, which means you could argue that all the other states have great programs. That's a non-point source joke. But we discovered that the agencies had no intention of honoring either the court order or the statute, and we then sought and obtained a second court order. Meanwhile, unrelated to any of this litigation, the Department of Forestry for the state had been considering revising the riparian protections for salmonid streams, but only the salmonid ones. Here we've pointed out that Oregon's water quality standards themselves are written to incorporate the load allocations as part of the water quality standards once EPA approves a TMDL. Temperature TMDLs in Oregon, because the temperatures are so high, often allocate zero allocation for all non-point sources to temperature. And so these TMDLs, essentially working through the standards, allocate zero to non-point sources, including logging. The Department of Forestry has chosen instead, however, to aim for a different part of the standard that gives them 0.3 degrees Celsius rather than 0. And I would say that there are two differences. One is the difference between about a 90-foot riparian buffer and 120 feet. And the other is that the one that they're aiming for only goes to the salmonid streams and doesn't cover that 70% of the stream network that protects things like frogs and salamanders. And so without paying attention to the TMDL, you have a situation where clear cuts can continue to go right up to the banks of those streams. This mess serves to underscore the importance of clarity in the development of TMDLs, significant aspects of which were, of course, upheld in the American Farm Bureau decision. While TMDLs defined to include load allocations are essential, I would say that if a state wants to point out that it is compliant with both CSARA and with Clean Water Act Section 319, even those load allocations must be translated into the necessary BMPs, which it turns out is both useful and probably essential to regulating point sources as well. Because controlling temperature pollution is a physics problem, there's no getting around the fact that there's a huge role for energy in addressing point source discharges. That is primarily that in order to achieve the numeric water quality standards, or normally a TMDL, you would need to use an energy-intensive chiller. Most everybody agrees that that is not a good thing for the environment, and therefore, at least for temperature, trading must be part of the equation. Quite literally, because of course, according to both EPA and the American Farm Bureau decision, TMDLs are an equation. But here's the problem. If you've allocated zero to the non-point sources, you haven't got anything left to trade because you've already been very generous to the point sources. And yet permits must be consistent with the assumptions and requirements of waste load allocations. That's in EPA permitting regulations. And in Oregon TMDLs, the assumption is full riparian coverage across an entire basin. No point source wants to decrease their allocation in order to be able to have the opportunity to trade, and yet trade they need to be able to do. So the Oregon solution is just ignore the TMDLs, just like in the logging situation. But that's not the only reason that people want to ignore TMDLs when it comes to trading. Water quality trading requires that we know what landowners are supposed to do under current law. Only then can we be assured that any trade results in what's called additionality, which is basically that the point sources are not getting credit for doing something that the non-point sources are already required to do. EPA's policy is that the TMDL's load allocations establish what's called a baseline of that requirement for non-point sources in order to assure the additionality. So in other words, if the state logging practices require 50-foot buffers, but the TMDL load allocations could be translated to mean that 100-foot buffers are needed, then 100-foot buffers are that baseline for trading. Allowing point sources to take literal credit for buffers assumed to be provided by non-point sources would be inconsistent with the algebra of the TMDL and therefore inconsistent with federal permitting requirements. In conclusion, the TMDL program would not be what it is without the dozens of citizen lawsuits that were brought to ensure that TMDLs were completed. But quantity, which is hugely important, particularly for permitting purposes, is not quality. And the quality of TMDLs will continue to be an issue so long as the states use TMDLs to maintain rather than change the status quo. While states have issued thousands of TMDLs with allocation schemes that were upheld in American Farm Bureau, almost no TMDLs evaluate the reasonable assurance of non-point source controls, but thereby undermining permitting programs, efficacy of non-point source controls, and appropriate trading. From a citizens group perspective, we must watchdog the quality of TMDLs to ensure that the entire water quality-based program actually functions as it requires. This takes persistence, the kind demonstrated by the Chesapeake Bay advocates, and if I may, the kind demonstrated by Northwest Environmental Advocates, which just won a precedent-setting case in the Second Circuit a few weeks ago, which was our fourth case over a 17-year span on ballast water discharges from ships. Finally, litigation has a very funny way of bringing to light fundamental questions many years after you'd think that they would be resolved. We learned that in Northwest Environmental Advocates v. City of Portland, represented by 3 attorneys, including Vermont's Pat Parento, all of whom went on to become law professors. Read into that what you may. It has always surprised me that that precedential holding had not come to light earlier. Likewise, American Farm Bureau demonstrates that even the very core issues of Clean Water Act Section 303D of whether a TMDL is comprised of allocations and reasonable assurance must be demonstrated in order for the TMDLs to be consistent with permitting requirements and remain seemingly unsettled decades into the program.
We have 5 minutes for questions. I'm sorry it's not longer. I apologize for the technical glitch. You were dealt with very elegantly and effectively. I apologize. Questions?
You guys are talking about broad TMDLs here, and I haven't heard the stakeholders that are being represented at the next level of this, where you have industry, and you have the government, and then you have the individuals that are out there as stakeholders as well. And that's a voice that I'm not hearing addressed really at all in how the process is being played out at this higher level. Because as somebody who sat on a TMDL down in Texas for 2 years through the E. coli on the Trinity, individuals are really kept out of that process. And I see this war going on and an exclusion of the regular stakeholder, which includes everybody in the room, where you guys are playing this out at a much higher level between government and industry. Where in the process at Chesapeake did individual stakeholders get involved, or down in the Everglades or up in Oregon, where the individual stakeholder is invited to the table?
Yeah, for the Chesapeake Bay TMDL, the Chesapeake Bay Foundation was very involved and engaged. We have a senior staff scientist who used to work for the United States government, Dr. Beth McGee, who spent years working with and on the various groups that were set up to develop the model that was used to come up with the allocations, set on work groups in which the Farm Bureau participated in, the home builders participated in the industry, as you mentioned. And when you look at the list of all the different parties who attended these meetings to help develop the TMDL, you are a bit overwhelmed by industry. But one of the things that didn't come out in our conversation and probably should have been emphasized more is that in the lawsuit, municipalities, industry, were there at the table on behalf of EPA and supporting EPA and supporting the TMDL because they had spent, and we as taxpayers have spent, billions of dollars. We had amicus briefs filed from major cities all across the country in support of this TMDL because they're sick and tired of paying for the non-point source load that the agricultural community refuses to bear. So we're there, we're fighting. Sometimes our voice is not as loud or as numerous, but we fought pretty hard for this one.
Yeah, how do you account for the immense stressors that climate change is going to put on systems from both point source and non-point source loading? I mean, there's challenges without what climate change is bringing us. When you factor in what science is telling us about increased loading, even if we don't add pollution from further, regular kind of pollution activities, how do you make sure that's accounted for when these TMDLs go into effect?
Well, in the Bay, the way the TMDL is set up is that there's going to be a recalibration in 2017. And so EPA is going to look at the various source sectors, their inputs, how they've done in all of the different states, and plug that into the model. And our understanding is that the Bay model is also going to take into account temperature rise of waters. I mean, that's the big problem now we're facing is that, as I mentioned, with increasing water temperature, we're having increased algal blooms. It's just, a great bath for algae to grow. So we're hoping that this next iteration of the model, it may have to make some adjustments on the allocations.
One more question on the way back?
You've been talking a lot about 303D and the difficulty of trying to control non-point sources through TMDLs and trying to get reasonable assurances. And I'm just wondering if 303E helps, because that requires the states to have this continuing planning process, and it seems there's some general language in there that requires the states to have a plan that will actually meet the goals of the Clean Water Act, and whether or not that helps in any of these cases to try to get the state to have a plan that actually works.
Yeah, go ahead, yeah.
I think the answer is yes, there is some promise to 303E and the regulations, which don't necessarily correspond all that well, I think. But it is very much a forgotten area, and although there is litigation around Cape Cod that has raised this issue to the fore. So my guess is that we're going to start seeing sort of more of that happening. But I think that the real key that makes TMDLs or anything associated with TMDLs different from a lot of other plans, and there are a lot of plans out there. I mean, you want to talk about the cost of TMDLs, they're just like enormous, vast quantities of plans stuck everywhere, is whether they are quantitative, numeric in any way. And so a plan that is associated with implementing a TMDL is something you can sort of sink your teeth into. You can say, here are the specific goals, we've translated them into more specific goals and specific items that need to happen and timeframes for those things to happen. A plan is just a bunch of yakking, and there's a huge, huge difference. So I think that's sort of the key role that TMDLs play in the planning process under 303E.
I just wanted to sort of make two comments. One is in response to John's comments about being overwhelmed by agricultural pollution. If you actually look at the history in the Chesapeake Bay, both prior to the issuance of the TMDL, both agriculture and the POTWs reduced their discharges to the Bay watershed by roughly 25%. And so it's wrong to sort of say, well, agriculture is doing nothing and the POTWs they're the good guys and we're the bad guys. The second, and in commensurate with that, the other thing to think about is the Bay watershed's population has increased dramatically, actually for centuries, but it continues to increase and is projected to increase more. And that, from all sources, means there's a greater load on the Chesapeake Bay. And so it's not a static problem. It's actually one that's increasing due to demographics over this gigantic area, and that has to be considered. The last point in response to the question about individuals participating, there were many opportunities to participate, but in a TMDL like the Chesapeake Bay, everything was based on modeling. And so to actually have an input into what comes out, you have to have people who are sophisticated enough to actually address the models that were being used. And these are very complex computer models. And even what John put on the board showed about the dead zone in the Chesapeake Bay, that's based on relatively limited water quality modeling because you have a gigantic area and the number of sampling stations are relatively small compared with the huge area of the Chesapeake Bay. So much of this is based upon, inevitably, based upon estimates and based upon computer manipulations of data. And that makes it hard for an individual living on the bay to just walk into a meeting and actually have an impact on what comes out.
Say one little thing about that.
Very.
Very little. Well, it's true. I mean, modeling is very much a black box. It is, to involve statistics, it's very difficult for people to get into. But sometimes you can look at things and you can see just what's wrong. For example, if you're modeling the temperature of an entire basin, and one of the assumptions that's stated is that you're going to use current temperatures that come from a basin that has been heavily logged and heavily grazed and heavily used for other agricultural purposes, and all the water has been taken out of the streams, you can be pretty sure that you're not actually modeling historical temperatures. So there is a role for people to be able to look at some of the sort of simpler parts of the assumptions, even if you can't see into the black box.
With that, join me in thanking our panelists. 5 minutes, starting at 11.